Well, welcome to the Week 3, Lecture 2 of HIH227, HIL227 on law and justice and its evolution in the 13th and 14th centuries in medieval England and indeed medieval Britain. I'll try to cover here not just developments in English law, but I'll also cover Celtic law in Ireland and Wales, for example, as well. Now, you might be wondering if there's any sense of justice in medieval Britain, if you've just taken in the previous lecture on the sort of run-up to the shameful expulsion of the Jewish community from England in 1290. But indeed, perhaps ironically enough, this same period, during the reign of Henry III, Edward I, even Edward II to a certain extent, is seen as a really crucial period in the development of the legal system and various judicial forums in medieval Britain. So I'm going to start here by talking a little bit about where law comes from in the British Isles. For most of continental Europe, to a greater or lesser extent, by this point in the Middle Ages, still there's a clear sense that certain principles in law, secular law at least, had come down to people in a roundabout way from the law of the old Roman Empire. That's not so much the case in Britain. Britain, of course, had been within the Roman Empire that had included England, Wales, parts of southern Scotland, though not Ireland. And Roman law had existed there, but it kind of faded away, especially after the arrivals of Germanic tribes in the early Middle Ages, the so-called Anglo-Saxons and Jutes, who had eventually supplanted such a large proportion of the native Britons in the British Isles that, of course, they would give us our English language, which is a form of an early Germanic language from those Angles. So that kind of wipes out most of the inheritance of old Roman law. In England, at least, there are some traditions which are vaguely reminiscent of old Roman law in Welsh Celtic law. And indeed, strangely enough, there are some bits in Irish law that have a vague similarity to certain aspects of Roman law. Now, having hopefully cleared the question of why we don't have law in Britain which looks like the Roman-influenced law of the continent, I'm going to talk about the two main forms of law that we do have in the British Isles. And these are two sort of divergent legal traditions. By 1066, one ideology is the so-called Celtic law, as we have it in Wales and Ireland. This is the so-called law of Hywel Dda in Wales, associated with the King of Deheubarth, Hywel Dda, who, at least in a legendary sense or mythical sense, is thought to have brought together various jurists of Wales around 950 to codify law. The reality is, though his name's associated with the law of Wales, he probably was never more than a figurehead to which it was later tied. Now, in Ireland, there's a form of law, again, called the so-called Brehon law. The word Brehon itself means judge, so it's maybe a little more transparent, the law of judges. Now, the law of Hywel Dda and the Brehon law, these two systems of quote-unquote Celtic law from Wales and Ireland, are very, very similar. They're based on the principle of compensation. A judge listens to both sides in a dispute, decides based on some basic legal principles who's in the right, who's in the wrong, and the party in the wrong has to pay compensation to the other party. Now, you might ask, what is the role of Welsh princes or Irish kings in this legal system? Well, they're enforcers, basically. There's pretty minimal involvement, but a notion has emerged by the later Middle Ages well, certainly by the mid-1200s, that if an independent judge listens to both sides in a dispute and decides what compensation ought to be given to the wronged party, that the Welsh prince or Irish king enforces that judge's decision, but the price for doing so is that the Welsh or Irish prince or king keeps a third of the compensation payment for themselves as a kind of fee for enforcing the judge's decision. Now that's very, very different from the so-called punitive law of Germanic origin that we get in medieval England. Now, in England, there are a couple of notions we need to keep in mind. Number one, an idea of what is right. So how we do things now is based on how we did things before, and that's flexible and it's not necessarily tied to a single law code, but rather it's something living and constantly evolving. The king then is the enforcer of all law, and so if you break the law, if there's a custom that, like, for example on a Tuesday one ought eat porridge, if you eat porridge on Tuesday, then in the Germanic system you are seen as having dared to break the king's law, and so the king will punish you for not having held to the law code. So matters of law are always between you and the king. And that's still the way common law works, in effect. We have crown courts for a reason. The crown has put in place certain laws, and when you don't follow those laws, you may be criminally prosecuted in the crown court. That's very different from the compensatory law of Celtic Wales and Ireland. I'll give you some more detail on compensatory Celtic practice here. Justice has a kind of process to it. Two disputants seek out a judge to hear their case. The judge hears the case, he applies principles of law which tend to be written down in a static law code in a book by the time we get to the 1200s. The judge interprets the rules in that book, he reaches a decision, he assigns compensation. Compensation is paid not just by the liable party, but also by his extended family, all the way out to people sharing the same great-grandparents. So that's kind of second or third cousins. How would you like to be financially liable for something that your second cousin does? I kind of doubt everyone listening to this lecture will know all of their second cousins on a first-name basis. As I mentioned, the Prince or King just in Wales or Ireland just enforces the judge's decision. There's little distinction in this system between civil and criminal law. Murder, personal injury, broken contract. Note here that the first of those is criminal, murder. Personal injury, we might have criminal or civil sides by modern reckoning, or broken contract by modern reckoning is just civil. That whole range of things there, murder, personal injury, and broken contract, all resolved through compensation. As I mentioned, this idea that people with the same great-grandfather all have to chip in to the liable party's compensation payment if someone is found liable, that means that there's a sense of collective responsibility. You need to know everyone in your family grouping. And indeed, this encourages kind of a policing of a sort, because if you could be made liable for perhaps a substantial amount of money for something that say, your second cousin foolishly does, then you're going to want to know who that person is, and you and a lot of others are going to want to make sure that person doesn't do something stupid. I'll give you a sense here of how compensation payments worked based on Galanas and Saraed, which are compensation payments in Welsh law for murder or injury. If you look at Galanas here, it's all calibrated to the so-called wealth of the individual. So there's there is no such thing as equality under the law in Celtic law. If you're the sort of chief of a kindred, so say you are the living great-grandfather who, is responsible for a large geographical area, and you're killed, then the compensation payment will be 180 cows. Keep in mind, say, one cow might be several months worth of wages if you were working for cash. And so these are extraordinary sums. 180 cows, even when spread across maybe 20 related persons, is going to be a crippling, life-changing amount of money to have to come up with. But notice here how the sums go down. So say you're just in a llawer, which is a noble in Welsh, but really just means a kind of free person of the related to the chief of the kindred, 126 cows. What if you're just a kind of free individual, just a random person on the street, say, 84 cows. If you're a teenage man, maybe 63. What if you're a so-called non-tribesman, you're just living in the area, but you're not related to the family who owns the land? You're a farmhand, say, 31. If you're a bondman, down here at the bottom, an unfree serf, 4. So there was no equality under the law. The law gauged your worth based on your social standing and assigned compensation accordingly. Even more shockingly, the Galanas of a woman was always half that of a man. So of a bond woman, 2 cows or 50p in silver. Shocking. When one kinsman murdered another, what do you do? For example, if you have 2 brothers and one kills the other, well, then it'd be the same family on the liable side as on the recipient side of the compensation payment, so that doesn't really work. Well, what you do is you expel the person from the community. If one person murders someone else within their own kin network, someone else sharing the same great-grandfather, they're considered a quote-unquote kin-wrecked person and banned from the community. A Saraed compensation, which is compensation for minor injury or insult, it works in the same system, but the sums are all scaled down to the lesser crime. There is effectively no capital punishment under Celtic law. That's a little bit misleading. There are certain instances of premeditated theft of high-value items. You can be put to death for that, for example. But those are really quite exceptional circumstances beyond the normal pale of what we would think of as felonies in English law, such as murder, for example. Some other Celtic issues here. There's one law for all freeman, peasant to prince, so there is one legal system, although that legal system does differentiate sharply in the value of compensation payments, reflecting what it perceives to be your social value as an individual. Marriage under Celtic law is a largely secular contract. A divorce is allowed during the first 7 years of marriage, but on the other hand, women could not own land ever. Land always belongs to the family grouping. A woman has to live with her birth family until she gets married. After she's married, she lives with her husband. If she gets divorced, she has to go back to her own birth family. If her parents are deceased by then, she'll probably have to live with a brother or sister. So very harsh on women's rights, apart from a couple of things. A, the capacity to get a divorce, and B, women did have a right, a legal right, to veto household contracts. So if you're married to a man who's not too bright, he wants to sell all of your cows for a handful of beans, you have a legal right to veto that. In England, there's a concept called dowry, which we'll come back to in a moment, where if a woman's husband dies, she gets to keep a third of his property to live on, kind of to keep her going as a single person. But in Celtic law, there is no dowry. A widowed woman has to return to her home family. And you can imagine if she's quite old by the time she's widowed, she might end up living with nieces or nephews, whilst the property she and her husband had had will pass on to her own male children. We can compare this to sort of the Germanic English law, what would become common law eventually, in its punitive system. Well, under this sort of Germanic law of the English, there is a civil criminal distinction. Civil cases where no violence is done, such as debt, contract, land, or ownership, are between two persons. They don't directly involve the crown. The crown at most will provide, or the local landlord at most will provide, a kind of forum in which you go in and argue with each other in front of a jury, perhaps, to decide whether or not you really own a debt, whether or not you've really fulfilled a contract. Under criminal law, these are instances when violence, or particularly major criminal activity, felonies as they're called. A felony used to be something for which the punishment was death, murder, arson, rape, and theft, the big ones. Under criminal law, you have broken the social rules put in place by the king, therefore you will be punished for them. Liability lies only with you as an individual and not with your wider family. If you break the law, you will be punished as an individual. There's a problem here insofar as victims don't get any compensation. They get the satisfaction of seeing justice done. That doesn't really help them out too much. Imagine if you're living in native Wales with Welsh law. Say your brother is murdered. He together with you run a farm, and you think, how am I ever going to run this farm without him? There's a real loss of manpower there, and I can't afford to hire a worker to help me. Well, compensation payment will come your way. You may use that large sum of money to, say, hire a helper, to find a way out of your troubled financial situation. Now imagine you're in England and you're running a farm with your brother. Your brother's murdered. You get the satisfaction of seeing the murderer hung. That doesn't really help you out of the difficult situation you were then in. So there are pros and cons of these different systems. Under the English system, the king is the guarantor of peace. If you are charged with a crime and don't turn up to answer for it, you are outlawed. And if you're outlawed, you're literally outside the law, meaning that someone could, in theory, kill you on sight without themselves becoming liable for any crime. There's also this really sticky, troubling thing called customary law in England. Most people in England are these kind of poor, unfree serfs. And everything I've just told you about compensatory law in England is law that applies between the sort of free landowning individuals. But what if you're part of that big swathe, perhaps as much as 80% of society, who are unfree sort of peasants at the bottom in England? Well, then you don't get the benefits of the kind of clear, punitive English common law, as it would become called. You live by your local village customary law, which is based on local norms of behavior, where your local village will hold a quote-unquote court and decide if and when you're liable to pay a fine or punishment based on the traditions of the village. Now, this tradition of the village custom uses a jury normally. In the early days, the quote-unquote jury is just comprised of all the adult men who happen to be present, but later it comes to be formalized as 12 persons. But the jury are chosen as jurors because they already know about what happened. Jurors are effectively witnesses. The idea of an impartial jury who doesn't know anything about the case is a strictly modern idea. In the Middle Ages, jurors in village customary law were chosen because they were perceived to know something about what happened. A court is provided over by a local official, usually the lord of a manor, who effectively just acts as a referee if there's any disagreement about what local custom is. Remember, if you're in that 80% of person who's your typical peasant, then your local lord holds your court. That's to say, he provides the court. Only freemen of the village, which would have been in a small minority round about 1200, could appeal. And in the Middle Ages, the term appeal meant not to ask for a case to be re-examined, but actually you sued your landlord who provided the legal forum, saying that he had failed to provide an impartial legal venue. So you go to a county court, say, and you actually sue the person who held the court rather than asking for your case to be re-examined on a kind of evidentiary basis. Now, we see a sort of a growing sort of top-down push in law in medieval England across the 1500s, across the 1200s and into the 1300s, whereby more and more of those poor peasants down at the bottom are continuously gaining access. More and more people are gaining access to the kind of formal common law provided by the king. So, quote-unquote, common law, as we know it now, describes the set of principles which the king decides he is going to employ in his main central courts down at Westminster, say, to resolve disputes between the richest freemen of the realm. So the king says, well, there are 1,000 villages with 1,000 slightly different ways of resolving a lawsuit regarding a debt, for example. But as king, I have to pick a process that we're going to use in my top tier court, so let's go with this one. And he'll pick something, usually the most common. And that becomes the kind of rubber-stamped royal version of law used in the king's common law courts, which are only available to free persons. Now, in terms of criminal law, the king's common law is that punitive law we've discussed right the way through, but the king also increasingly provides venues for dealing with civil litigation where no crime has been committed, but rather where a contract or a debt or a land dispute needs to be heard. The king's common law decides to adopt the use of a jury. In civil cases, the punishment and compensation are set by the jury, maybe a fine and some money to be paid to the plaintiff. In criminal cases, felony cases, rape, murder, arson, serious theft, are all dealt with by hanging. Keep in mind, in the Middle Ages, to say something was a felony meant you would be put to death for it if found guilty. For lesser criminal activities, fines are set. Common law reinforces the social order. In all cases, a jury are chosen from the county where the disputed event is claimed to have taken place. Say if you want compensation for, say you bought some grain off someone and they failed to deliver all of it, and you struck the deal in Wiltshire, say, then a Wiltshire jury would come and decide the case. The idea here is that people of Wiltshire would probably have known something about what was going on. Again, the idea that the jurors are witnesses, in effect. The jurors would also be of the same strata. So if you were of the kind of free merchant class, they draw jurors who were free merchants. If you were a kind of wealthy landowning noble, then other nobles would be packed into a jury box, and so forth. The king's common law courts are expensive. If you want your case to be heard, not in some customary venue, but if you have a civil dispute, say a contract, and you want it to be heard in the king's official common law court, you had to go yourself, or your lawyer had to go to London, to Westminster, and get the king's chancellor to write out what was called an original writ, and to pay a big fee for it. This was a scrap of paper that had a wax seal on it. It said, in the name of the king, so-and-so has complained to us that he bought grain and you didn't deliver it to him, or come to court and explain why not. In terms of the reign of Edward I, and indeed his next couple of successors, Edward II and III, this is a period that always used to be referred to as the age of the so-called triumph of common law. Indeed, Edward I has often been called the English Justinian, because he formalized and professionalized national civil and criminal courts at Westminster, and those were the central courts for the richest people in the realm. There is a court of common pleas for civil litigation between the kind of ultra-rich landowning class present at Westminster from 1215, but he works to streamline it and to make sure there are good judges available there. There's also another case similarly held in Westminster Hall at Westminster called King's Bench, and that dealt with major criminal affairs from around the country, such as murder or arson. Now, the Crown works to set up in the 13th century county courts, which can offer this special royal common law, but do so locally. And when they set up county courts, in fact, you can bring a case there for a fee and enjoy the king's own special common law, and judgments in the county court will be enforced by the king's official locally, by a sheriff. Keep in mind, if you're down in one of those customary courts in the manor, you're relying upon the local lord to enforce judgments there. So he has less pull. The Crown actually begins to reserve for itself all felony cases and civil cases worth 40 shillings or more. But keep in mind, in 1272, there were many areas where local customary law did everything, providing all law, even concerning felonies and free men. And these are so-called liberties, where just because they always had dealt with everything, including major crimes like murder, they just were carrying on doing so. And so Edward I tries to address this with a series of inquiries called Quo Warranto, held between 1278 and 94. Whilst it never ends up visiting all of the country, it visits a lot of places, and it asks basically, if you're hearing cases, felony cases such as murder, or you're hearing civil cases worth 40 shillings or more, by what warrant, i.e., by what royal permission do you claim to be able to have that jurisdiction? And in fact, because those places had been enjoying that jurisdiction from before there were written records in most instances, the Crown is able to say, well, if you don't have any documents to prove why you should hear those cases, then you can't hear them, and manages to be able to claim jurisdiction in a lot more parts of England. This is all part of a process of bringing the King's official approved version of common law, both civil and criminal, within reach of ordinary people. Edward I extended common law. Of course, he also extends common law to Wales. After Edward conquers Wales with the so-called Statute of Rhuddlan or Statute of Wales of 1284, he gets rid of Welsh compensatory law for criminal matters and replaces it with English punitive criminal law. He also attempts to do the same thing in Scotland whilst he's occupying Scotland during the so-called Scottish Wars of Independence. The same is true of English possessions in Ireland. There is an attempt in the so-called Pale of English control to ensure English criminal law is used there. Edward makes regular and then permanent so-called assize courts. These are now what we call circuit courts, whereby judges visit counties, one county after the next, going to each county town to hear Crown pleas, that is to say, felony cases or civil cases where the value of the plea, the say debt or contract, is 40 shillings or more. 40 shillings is £2 in old money, by the way. Keep in mind that a worker's daily wages in these days was about 2p, and in old money there's 240 pence to a pound. Edward also works to formalize the so-called assizes. There are assizes of gaol delivery, which are to say appointments of a judge or a couple of judges usually, who would then be told to go visit the county jail, or gaol as it used to be pronounced, county jail of individual counties, and to hear all of the felony cases of people awaiting trial in those jails. Edward I also makes a number of royal statutes. Common law was by nature unwritten. As I mentioned, in Celtic law and Welsh or Irish law, there is actually a book of laws, a book of the law of Hywel Dda or a book of the Brehon law. And a judge would read that book, and a judge would make a determination for compensation. Common law is really unique insofar as it is not formally written down in a single book of laws. Common law is a process. I mean, that's a phrase you should never forget. Common law is a process. It is not a single rule, but a process. We do it this way because this is how we did it last time. So I'm talking here about jurisprudential development. But if common law is a process, then what are statutes? Well, statutes are effectively rules of the game. We still have statute law today, but as it was perceived then, if common law is a process of arriving at the truth through a series of operations in a court, then statutes were kind of guides for the best way to undertake those operations. By operation, I mean, for example, determining whether or not a contract is valid based on a number of factors. Statutes are written down, and in fact, Edward I is the king who invents what are called the statute rolls. He says we need to write down statutes. In fact, he says we need to go back and write down previous statutes so that we don't forget what's been done in the past. And when the statute rolls come out, the first statute written in them is Magna Carta from back in 1215, not surprisingly. Edward I, with Parliament, agree more statutes, that is to say, more rules for how the legal system should operate, than all of his predecessors combined. The Statute of Westminster in 1275 is virtually a complete overhaul of the English justice system. Basic things such as punishment for rape are entered into law in the Statute of Westminster and strengthened in Westminster too. I mean, unbelievably, prior to Edward I, rape had not been a felony, but rather that either the rapist was castrated or the rapist was forced to marry his victim, based on an assumption that the rapist would be a rich person who had taken advantage of a poor person, and thereby he was punished by marrying the poor person, and the poor person effectively gained a rich husband. I mean, it's dreadful. But Edward I is the person we have to thank for such basic things as recognizing rape as a heinous crime it is, and making it punishable by death, ultimately. Edward I also decides he's going to clean up corruption. He holds what are called the so-called show trials. He's away in France for a bit in 1287 to 1289. 1289, he turns back up in England, and there are lots of people complaining of corruption among his justices. So he institutes in statute penalties for judicial corruption. He introduces oaths of office. I mean, geez, how basic is that? And in 1289, after he returns from France, he investigates corruption claims against his top judges who had previously not been paid a regular wage, but had been appointed because there were rich people who could use their leisure time for the good of the kingdom by acting as judges. And of course, a lot of them take bribes and so forth. Many judges, including the Chief Justice of the realm, are tried for corruption and ejected from office, fined, or even banished. Edward then introduces professional lawyers to act as justices and Chief Justice of the central law courts. So he replaces rich lords and churchmen with professional lawyers, who of course now have to take the oath of office, and they're also paid a regular salary, which is very high, and they're appointed for life, and that's seen as guarding against corruption. In the Middle Ages, the idea was if you want to make sure someone's not corrupt, you pay them so much that no one else can give them a bribe big enough for it to be worth it for them to risk their skin taking a bribe. In terms of mechanics of justice, in the King's Central Courts in particular, the plaintiff pays for a writ, this sort of bit of paper that says, is issued to the local county sheriff in the King's name. It says, in the name of the King, do right by person X, or come to court and explain why you haven't. The defendant's allowed to miss 3 sessions of court. He can make excuses for up to 3 sessions saying he's ill or away on business or whatnot. When the trial finally comes, if you're found guilty, you must pay, in a civil case, you pay compensation, or you're imprisoned until you come up with the cash. More accurately, you're imprisoned until your friends and family come up with the cash. Criminal law, as I mentioned, is this really distinct Germanic punitive law. You can bring cases by your own writ. Say if you have, most importantly, Edward I institutes a system here. You can say, you can bring an appeal, it's called, of not to be confused with the other kind of appeal where you don't like the outcome of a case, but you can bring a complaint, say for example, of rape, and you can prosecute that criminal claim much the same way as you would a civil claim, where you have to introduce the evidence, make the complaint. Or also, excuse me, in due course, once the Crown is made aware that a crime has happened, the Crown will investigate it for you. And so what a lot of people do is bring a complaint, and then rather than prosecute the complaint on their own, once it's in the purview of royal officials, they then drop their private complaint and the Crown takes over and prosecutes it for you. Keep in mind that the Crown didn't have investigative persons like we have today, like police, to go out and deal with the crime at the ground level. You have to bring the crime to the attention of officials. If it's a felony, you'll be punished by death. If it's something minor, you'll be punished by a fine. And again, if you can't come up with the money, you'll be thrown into jail until you, or more accurately, your family and friends, can raise the money to get you out. So I'm going to wrap up by saying a couple of words about the medieval prison. For your average Joe, medieval people thought long-term imprisonment was cruel and unusual punishment. Prison was thought to be something for holding people, to coerce them to either pay an unpaid debt, or when you're arrested, you had to enter a plea. Are you innocent or guilty? And of course, if you're found guilty in the Middle Ages, all of your goods are confiscated to the Crown, and indeed, if you have a wife or children, they lose everything because your property is taken by the Crown. And so people who know they're going to be found guilty one way or the other sometimes used to refuse to enter a plea at all. They'd rather just languish in jail for the rest of their life for the good of their family, effectively. And so jail was thought as this terrible place where you threw people until they were so miserable they would enter a plea. If you, for example, are a debtor and you're a merchant, you're thrown in jail, well, of course, that's really just rings an alarm bell to all your other creditors that you're insolvent. And so they'll usually swarm. And so once you're in jail for one unpaid debt, usually all your other creditors will swarm. It's kind of like a bankruptcy rush. When you're in jail, you have to pay for your own time there. You or your friends or family have to pay for the cost of your food and maintenance. If you're in there for years, the prison warden will keep a tally of all of your food or your blankets or whatnot. And if you ever get a chance to get out, you'll be given a bill you have to pay before you can leave. This leads to the potential for a poor person in prison to never be able to get out because they can't clear their original debt, let alone the really quite substantial fees that run up for looking after them owed to the warden. Edward I pioneers holding prison as a punishment. This is something totally new. He does this first with when he sets about to criminalize rape. In Westminster 1, he sets out a law that says a rape is punishable by 2 years in prison. This eventually is ramped up to 7 years in prison, and then eventually the third statute becomes punishable by death. But prison is perceived as really cruel because the mortality rates, once you're thrown into jail, is about a 1 in 2 chance you're going to die anyway, just from poor sanitation and so forth. It's interesting what Edward I does here in the 1270s and 80s, making a punishment of prison a punishment in and of itself, because it happens about the same time as a similar shift in Italy. For example, in the 1300s, some Italian city-states, such as Florence and Venice, who don't want to put criminals to death, instead hit them with a huge fine, saying you can leave jail as soon as you pay the fine, but they make the fine so big that they know the criminal will never be able to pay it, therefore they'll be in prison for life. And so there's an interesting shift taking place across Europe just at this period. I'll wrap up with saying something about the other use of the prison here. Prisons are also used to gain ransoms, particularly for the nobility. Normally, if you capture somebody in war, a POW effectively, you hold them in prison until their family or indeed their home country can raise money to get them out. This is an important aspect of how you fund war. If you have a successful battle, such as the English did at Crécy or Agincourt, you take lots of prisoners and can get lots of money by ransoming them back, which you can use to then further fuel your own war effort. Alternatively, political prisoners are often there are often political prisoners in the Middle Ages. For example, David ap Gruffydd, the brother of Prince Llewellyn ap Gruffydd of Gwynedd, was a hostage of Henry III for a time in the Tower of London. He actually escapes unbelievably, supposedly, by climbing down bed sheets tied together made into a rope, if I remember right. Execution for nobles, and especially royalty, would have been seen as upsetting the social order. People at the top ought not be seen to be punished like people at the bottom. And so often when there are really problematic nobles, they're whisked away for lifetime imprisonment, or they're quietly starved to death in prison, and then they can say, oh, well, died of natural causes. This is what happens to Edward II and indeed Richard II in 1327 and 1399, respectively. In both cases, they're thrown in jail, and then it's understood they're starved to death. There are some other stories about what happens to Edward II in Berkeley Castle, but probably starved to death. It leaves no marks on the outside of the body. Prison does not represent physical torture in England. Torture, as you might picture it from the Middle Ages, is not at all allowed in England. England's rather unique because the Crown, of course, enforces the rules. One rule is you may not commit violence on one another, and the Crown has a monopoly on violence in England in that sense. And torture is not allowed. So England, and wherever you have English common law, you don't have torture. In contrast, torture is seen as a reasonable way of getting a confession, where you don't have, where you have suspicion but no evidence on the continent in Germany or France. And that's because on the continent they have this legacy, a revived legacy in the later Middle Ages of Roman law, and because Romans had thought torture was okay to get a confession where there was reasonable suspicion, French and Germans used torture. England did not use torture.